It gives me the great pleasure to welcome you all to the number 6 lecture of Mission Nyayadrishti Samvad, an ambitious marathon series of 100 online lectures initiated by the Department of Law, School of Legal Studies, Central University of Karnataka. This mission was formally inaugurated on 24th September by our esteemed Vice Chancellor, Professor Battu Satyanarayan Sir and Honorable Justice H.P. Shandesh Sir of the High Court of Karnataka. The initiative is envisioned as a step forward, expanding access to legal education in alignment with Viksit Bharat 2047 and Sustainable Development Goals. By inviting eminent scholars from India and abroad to share their expertise voluntarily, the mission ensures accessible, inclusive, and equitable education for learners across the country. It is scheduled every Friday for the next 2 or 3 years. It seeks to bridge the gap between academic and the learners, fostering dialogues, critical thinking, and global exposure. Today, we are privileged to begin this journey with Lecture 6, and I am delighted to introduce our distinguished resource person, Dr. Prakriti A.R. Ma'am, Assistant Professor of Law at Vidya Varataka Law College, Mysore. Dr. Prakriti A.R. Ma'am is an accomplished academician with over 17 years of rich teaching and research experience in the field of law. She has served in several reputed institutions, including Sarada Vilas Law College, SPRR Mahajana Law College, and now continues her dedicated service at Vidya Varadaka Law College, Mysuru from August 2016 to till date. In addition to her extensive teaching experience, Ma'am has been actively involved in research and has published more than 30 research articles in various national and international law journals. She has also presented over 70 research papers at state, national, and international seminars and workshops organized by the Government of Karnataka, various universities, and other academic bodies. Her academic contributions go beyond the classroom as she has been a visiting faculty at the Police Academy, the Prison Training Institute, and the Administrative Training Institute, Mysore, sharing her insights on law, justice, and governance with the trainees and professionals alike. Ma'am has also attended a RUSA-funded online refresher course in human rights and pandemic organized by the UCC Human Resource Development Center, University of Mysore, where she secured an A+ grade for her outstanding performance. Today, she is here to enlighten us on the topic that lies at the core of our Constitution, that is, judicial activism for uplifting the fundamental right in India. We have honored to have her with us today. I warmly welcome you, ma'am. The session is now over to you. Ma'am, kindly please on your microphone. Ma'am, please turn on your microphone.
No, but now also it is not coming. Yes, your video is visible, but your audio is not coming. Maybe you please join on your mobile. The laptop. laptop will be working. Do you have any other device? Yes, ma'am. Your slide is very well. Yes. Yes, yes, you just know.
Sorry to interrupt. The resource person is having a little problem with the audibility, so she will be resuming soon. Kindly keep a
Hello.
little patience.
Hello,
Yes,
sir.
ma'am. Yes, yes. Now it is
Now
audible, ma'am.
it's audible, sir.
Yes, yes.
Okay, shall I proceed, sir?
Yes, ma'am. Please.
Okay, okay. So very good afternoon, all assembled here, and I just always grateful for this coordinator for giving me a great opportunity to present my topic on the concept of judicial activism for the upliftment of fundamental rights in India. So before that, let me introduce myself. Myself, Dr. Prakriti, Assistant Professor of Law, Vidyavardhaka Law College, Mysore. So for this session, what I'm going to make a presentation that this is nowadays we are always worried about an activism concept. Activism means what extent the judiciary is very active in relation to protection of fundamental rights. So based on that, I just started with an introduction and the concept of judicial activism and what are the components of fundamental rights under the Part 3 of our Indian Constitution, along with the role of judiciary for protection of fundamental rights and the contemporary situation. What are the contemporary situation and the challenges faced by the judiciary regarding to the protection of fundamental rights? And lastly, conclusion. So these are all the components of the content of my presentation. Before I just start regarding to the introductory part, I would like to make a Montesquieu separation of theory. So as you know that there are three parts, that is three organs of the state, that is legislative body, executive body, and judicial body. So they have their primary powers. For example, the legislature shall make the law and executive shall enforce the law and the judiciary shall interpret the law. So the main object, they have to create the relationship between all the three organs of the state, that is executive, judiciary, and legislation in India. So by that time, the doctrine of separation of power, which propounded by the Montesquieu, is not strictly followed in constitution. So the provision itself make it that even the judiciary has exercised the legislative power, executive exercise like judicial power, like a pardoning power has to be exercised by the president and the governor. In case of an appointment of the judges, again the legislature shall place very important role, executive shall play important role. So hence there is no strict separation of power as to be propounded by Montesquieu in our Indian Constitution. So based on that, we'll start it with an introductory part. So here, the main component has to be stated that the judicial activism has been crucial to for the upliftment of fundamental rights in India, where the judiciary plays proactively interpret and enforce the rights of Indian Constitution. And also either it may be a constitutional right or it may be a fundamental rights. So when again, it is contending that there is often stepping when the legislature or executive fail to do so, then judiciary plays very important role. As you know that Article 32 itself is an soul of our Indian Constitution. So there was a constitutional assembly debate was going on by the time. So there was an one of an the member of an assembly. So they asked question to the Dr. B.R. Ambedkar. They stated that which part of the Indian constitutional article is very important. By the time Ambedkar has to be replied that Article 32 itself is it's a kind heart and soul of our Indian Constitution. Again, the concept of ubi jus in remedium, which where there is a right, there is a remedy. So hence, unless otherwise constitutional rights are not protected like a remedy by Article 32, there is no use for the enforcement of rights. So hence, Article 32 itself is a kind of that is a soul of our Indian Constitution. So by the time even Article 226, its power given to the High Court through development of public interest litigation and also broad interpretation of a right, that is right to life, and also judicial activism, which
Ma'am,
can be
sorry to
extended.
interrupt. Hello,
Yes,
ma'am.
sir.
Are you moving the slides?
Yes, sir.
But the slides are now it is moving. Yes.
It's not moving.
Okay. It was not moving. Now it just moved.
Moved, right? Okay. Shall I proceed, sir?
Yes, ma'am. Yes, ma'am. Please.
It's moved now. It's moved, sir.
It is. It has moved to the next. Yes, yes. Now it is moving, ma'am. You can proceed, ma'am.
Yes, sir. Yes, sir. So based on the legislature, executive, and judicial relationship, we just find out separation of power. I just discussed regarding Article 32 and the 226, the role played by the High Court and the Supreme Court under Article 226, and also intervention of the various, the right has to be propounded under Article 21. Again, the main question arises before us that what is judicial activism? So main thing, the judicial activism means the kind of judicial ruling that anything which has to be suspected based on personal opinion. It's rather than the existing law which passed by the parliament. At the same time, there are certain components like judicial restraint, judicial review, judicial activism. So there's a kind of a definition we have to analyze. So how the judicial activism has to be different from the judicial review and judicial overrule. So based on that, we try to analyze the concept of judicial activism along with the protection and upliftment of fundamental rights in India. As you know that, so there are certain fundamental rights under Part 3 of our Indian Constitution are protected to the citizen as well as non-citizen. In case of right to equality under Article 14 to 18, again right to that is of freedom, Article 19 to 22, right against exploitation, Article 23 and 24, right to freedom of religion under Article 25 to 28, and also cultural and educational right, Article 29 and 30. Again, right to property, again, Article 31, it has to be repeated. Right to education, it's a kind of a fundamental right. Through the judicial activism, it has to be introduced. One of the fundamental right under Article 21A of Indian Constitution, and the last right, right to constitutional remedy itself is a right of fundamental right under Part 3 of our Indian Constitution. So next we'll move on to how the judicial activism plays very important role. Means definitely the judges must be active role for the interpretation of that is a provision of India, the law which passed by the legislative body, and the role of the judges to examine and decide and resolve the dispute of a state administration also played a judicial activism, and the judges' decision will be binding for the public. So these are all the component we have to try to analyze concern to the judicial activism. So next concept, there is a two concept we try to understand: judicial activism and judicial restraint. So how judicial activism is differ from judicial restraint means the word restraint itself it stated that always judges try to find out intention of the constitution, that is a restriction has to be made. But in case of activism, the look behind the original intention of the framer. So this will be the main textual difference between judicial restraint and judicial activism. In case of restraint, always judges look into the intention of the legislature. That is a literal interpretation always plays very important role in the judicial restraint. But in case of a judicial activism, the constitution shall treat it as a living constitution. Even the judges has power to make changes over time. Again, in the judicial restraint, the respectful of the precedent which passed by the court, and here active action is necessary and appropriate at the time. Again, the activism plays very important role. Again, there is an argument that changes has to be made, like a constitution can only made again through the amendment process. Based on that, but in case of an activism can be involved interpreting and enlarging the law has to be made by the parliament. So hence, there is a kind of a component we just know regarding to the restraint and activism. Again, another important concept, judicial review and judicial activism. Whether both are same or both are different? Yes, it is a both are different. Judicial review means interpret the law based on the constitutional standard. Means the review has to be made by the court. But judicial activism means adopt the law to reflect evolving social and economic dynamics. Because law is not a standing, it shall be a dynamic. So based on the needs of the changing of the society, definitely through judicial activism, the societal and economic dynamic has to be adopted. New law by the court is called judicial activism. There is a scope in consent to the judicial review, access constitutionality and the status of laws and the action. But in case of judicial activism, they influence policy outcome based on judicial preference.
Ma'am,
We
sorry
have,
for interruption. Ma'am,
yeah,
sorry. Who is Silpa? Please mute your mic. Please mute your mic.
yeah.
Silva,
There
please
is a
mute
kind
your
of
mic.
disturbance. Huh?
Yes, actually,
Yeah,
some participants' mic was not muted.
yeah, yes.
Ma'am,
Okay,
please
now
continue.
shall we
Sorry for the
proceed?
interruption.
Okay, sir. Okay. So again, in case of judicial review, again the rule has to be compliance with the constitution. But in case of judicial activism, the main object of the court has to promote the justice along with addressing the gap in the legislation and also executive actions. So this is kind of a difference between judicial review and judicial activism. Again, next, another important concept that is judicial activism and judicial overreach. See, there are a lot of word which has to be used by the judiciary in which any proactive standard point, we just used proactive standard point has to be used by the court, depend upon the citizen right and advancing justice to the society. Like a intervention of public interest litigation, there are a lot of judgment passed by the court. It is nothing but proactive standard points. It's nothing but a judicial activism. But judicial overreach, it is an extreme form of judicial activism when the court act behind its jurisdiction, like interference in the executive and legislative jurisdiction. This concept is called judicial overreach. But based on that, in case of judicial is a final interpretation of constitution, like Article 32 and 226, definitely if there is any invalidate law, constitutionality of law shall be decided by the judiciary. Any the law has to be passed by or any rule has to be made by executive body which inconsistent with the law or part 3 of our Indian constitution. Definitely the court has power to look into the constitutional validity through their activism. That is called judicial activism. In case of judicial overreach, that is, it is a kind of a violation of separation of power. For example, all the authority exercise their power, legislative body, executive body, judicial body. But Article 142 of our Indian Constitution, which specifically example for judicial overreach, like even the court used that as a modified and arbitral award, that is a risk in judicial overreach. For a best example, which consent to the judicial activism, that is Vishaka versus State of Rajasthan, which was decided by the Supreme Court in the year of 1997. At the time, there was an absence of a law for the ensured protection towards to the working women. She faced any sexual harassment at workplace. By the time the Supreme Court just observed SIDA Convention, that is Convention on Elimination of all forms of discrimination against women. So this is a best example for judicial activism. Along with that Menaka Gandhi case in the year of 1978, again, the court proposed the concept that is an interpret procedure established by the law, that is due process of law. These two concepts, it's nothing but through judicial activism. But in judicial overreach, national anthem case and also Shamia Narayan Chokkasi versus Union of India case and also liquor ban near national and state highway. So these are all the examples which consent to the judicial overreach. So based on this different aspect, let us move on to the in detail concept about judicial activism, how they plays very important role for the upliftment of fundamental rights in India. For example, yes, judicial activism is the protecting the fundamental rights. Secondly, filling the legislative gap. And thirdly, ensure government accountability. Along with there is an environmental protection and also governance reforms. So these are all the component in which the judiciary plays active role for the protection of the rights. So let us move on to the importance of judicial activism. Why judicial activism is an important means for the intervention of public interest litigation. It's a kind of an, for example, any person can go to the Supreme Court either loco standi means other than that, even any the public interest has to be implied, any issue which concern that, even for the purpose of the upliftment of public interest, they can move High Court and the Supreme Court under Article 32 and the 226 against public interest litigation. It's a kind of an importance of judicial activism. Again, the broadening the rights. So how the concept of broadening the rights, already Article 21 has to be specifically pointed out, life and personal liberty, which means that here the provision made it very clear that no person shall deprive right to life, personal liberty without procedure established by the law. But nowhere in the Article 21 define what is life and what do you mean by personal liberty, what are the component of a life. But the judiciary plays active role for the interpretation of right to life and the personal liberty, like right to livelihood, right to health, right to education, right to privacy, by the various landmark cases. Again, the third importance of judicial activism, activize the vulnerable. For example, marginalized section of the people, even though offender, uplifting the human dignity. Hence, there is example excluding the some of the right, like a right to speedy trial and right to legal aid. So these are all the right has to be included based on the activism played by the court and filling the gap. This is most important concept that we try to analyze. In case of any legislation has to be passed by the legislature, some of the provision is silent over the situation. By the time, always the court plays very active role to make effective tool for the fulfillment of the gap between that is a legislature and also implementation aspect. So hence filling the gap also it's a kind of an importance of judicial activism and judicial review. Yes, any law which passed by the constitution, any that is a parliament which inconsistent to the provision of constitution, the court has power to review on that in case such law as declared as an unconstitutional law. So hence judicial review, it's a kind to declare law or the government action unconstitutional if it's violate the fundamental right. And I already mentioned the judicial interpretation, that is interpretation which made to the Article 21 and also various issuing the writ. Judiciary can also issue the writ like a five kinds of writ: habeas corpus, mandamus, certiorari, prohibition, the quo warranto in case of any violation of fundamental rights or legal rights under Article 32 and 226 and checking the power. So this is main component of separation of power, that is a crucial check check and the balances, that is check on the power of the legislature, that is on also executive, ensuring what are the action which has to be confirmed by the constitutional standard. If it is not so, again the judiciary plays active role for the interruption for whatever the checking power in case of they may chance of an abuse or misuse. So hence the judiciary plays very important role to checking the power exercised by the legislature and executive body. Next, historical development. Let's move on to the whether any person who played very important role to originate the concept of judicial activism in India, means there is no single judge universally created, but we can found out Justice Krishna Iyer, V.R. Krishna Iyer, and also Justice Bhagavati are widely considered the pioneer and the founder figure of judicial activism in India. Along with that, Justice Chinnappa Reddy and D.A.J. Desai, also the kind of a philosophy has to be introduced through public interest litigation. So we could have analyzed the various judgment which passed by that is Justice V.R. Krishna Iyer. So it is based on the upliftment reforming made to the criminal justice and also human right and the stand up of marginal sections of the society. So how means through the judicial activism and also Justice Bhagavati played very important role to enlarge to the public interest litigation and also introduce the concept of absolute liability. So in case of most of the environmental issue, the concept of strict liability to absolute liability, the best example, UCC versus Union Corporate Corporation of India, that is Bhopal gas disaster case. Here, the court has to be pointed out the absolute liability doctrine and also polluter pay, various the principle has to be evolved by the court based on intervention of judicial activism. So, along with that, we'll find out a major, that is origin of judicial activism. First time in the American historian and the educator Arthur Sachinder Jr. So he is the person, he has to be used in the year of 1947. That is concept of judicial activism. Along with that, V.R. Krishna Iyer, Bhagavati, Chinnappa Reddy, D.A. Desai also established the groundwork for judicial activism in India. So based on that, let us move on to the meaning. of judicial activism. Whether there any proper definition has to be given to judicial activism means there is no proper definition has to be given. But literal meaning of judicial activism means the role of the judiciary, which means proactively defining the citizen right and also advancing the social justice. So these are all the two component has to be included in the definition of judicial activism. Hence, the court played active role for the ensuring that legislature and also executive branches of government fulfill their constitutional obligations. So hence, judiciary always check over whatever the power has to be exercised by legislature and also executive. So let us move on to the judicial activism method. What are the method has to be introduced? For example, judicial review, I already explained. Public interest litigation. Again, through public interest litigation, there are so many that is a doctrine and so many that is a concept has to be introduced by the court and constitutional interpretation along with international statutes for the protection of constitutional right. For example, SIDA Convention, that is Convention on Elimination of All Forms of Discrimination Against the Women, has to be applied for the protection of the women, that is working women, in case of any working women who face sexual harassment. Along with that, upper court authority to supervise into the inferior court through judicial activism. So let us move on to the landmark cases in connection to the judicial activism movement. Firstly, it has to be begun in 1973 when Indira Gandhi movement was denied by Allahabad High Court. After that, 1979, again for the question concerned to the Bihar under trial prisoners which already served longer sentence, it's nothing but violation of their right. Again, the Supreme Court has to be involved through judicial activism. And another important case, Golaknath case, that is an amendment provision. Again, in the instant case, one of the issue which has to be arised that in case modification of fundamental rights, again, the Supreme Court has to be concluded to the new Constitution Assembly that need to change the fundamental right, but shall not to be questioning consent to the amendment of basic structure. So hence, Section Article 368 make outline the process of amending the Constitution. Hence, Golaknath case also plays very important role to make active role played by the judiciary. Again, freedom of press. Sakala Newspaper Private Limited versus Union of India. Again, in this case, they'll point it out consent to the price of newspaper according to the Newspaper Act of 1956. Again, Order 1960. Again, the Supreme Court ruled that there is a major changes has to be made by the Supreme Court in the Sakala newspaper case. Could not to be subject of same regulation. Hence, the newspaper it's considered as a business in case of it is exchanging the ideas and the information. So hence, the decision which made by the Sakala newspaper, which has to be broadened the protection of freedom of speech and expression under Article 19(1)(a) of our Indian Constitution. Again, reservation policy, you could have seen Balaji versus State of Mysore, 1963. Again, the Supreme Court reasoned that economic backwardness also root cause of social backwardness. Here, the court has to be made certain distinguished between caste and the class. So, based on that, caste should not only be access of backwardness, also economic backwardness shall be taken into consider. Again, the reserved category percentage total should not be exceed 50%. Again, it was decided in Article 14 as well as Article 15 and the Article 16. So, based on the certain component of that as a fundamental right, yet the judiciary plays very important role in changing the reservation policy by various landmark cases. And also doctrine of prospective overruling. So, in the case of Golaknath versus State of Punjab, here one of an issue which arises before the court in connected to the prospective overruling. But the court held that, so this prospective overruling first appeared in the American legal system. So it stated that specific case will affect it to the future, but it will no retrospective effect on the previous decision. So this prospective overruling addressed the constitutional validity at 17th Amendment. So it determined the Parliament locked to the authority which amend Part 3 of our Indian Constitution and also breach any fundamental right. Again, doctrine of basic structure, as you know that Keshavananda Bharati versus State of Kerala, which were decided by the Supreme Court in the year of 1973. Again, the Supreme Court has to be along the concept of that is basic structure. Again, Indian constitutional, it is kind of an Indian constitutional jurisprudence, which has to be confirmed under Article 368, that is an amendment power, but the basic structure shall not be abridged. So by 7-3, totally 13 judges, which has to be ruled the broad power of amending power of our Indian constitution. Finally, even the parliament has power to amend the law, but shall not abridge or inconsistent with basic structure which is propounded by, that is a court in the case of Keshavananda Bharati versus that is state of Kerala. And along with that ABS corpus case, ADM Jabalpur case in the year of 1976, again the Supreme Court judgment ruled the right to move to the court enforcement of fundamental right during an emergency period. Again, so there was an negative aspect of an activism. Here court held that during an emergency, but person could not move to the court to challenge their detention, even though violation of fundamental rights and personal liberty has to be stated. This contravention decision considers a dark chapter in Indian legal history. So hence, later it was overruled by the court. But in the year of, that is 1975 to 77, what was an emergency situation? By that time, all the, that is the government has to be denied, that is the fundamental rights and individual rights to the maintenance of Internal Security Act, MIC-ACA. So main issue has to be raised before the court under ABS corpus case, that is ADM Jabalpur case. Could the right to personal liberty of right under Article 21 suspended during the emergency? Secondly, judicial review of such detention permissible. In the two issue, the court has to be decided majority, means the court of majority held that right to judicial remedy also be suspended during the emergency. So hence, this considered dark chapter of Indian legal history, but although it was laterly overruled. Next important case, Husainara Khatun versus Home Secretary, that is state of Bihar. So and also Kathari versus state of Bihar, 1979 and 81. Again, the court has to be uplift the complete justice. Again, based on that, Justice P.N. Bhagavati also be considered as a father of Indian, that is judicial activism, strengthening the concept of several decisions, like ensuring complete justice to the weaker sections of the society. So based on that, judicial activism in India can be divided into three broad stages. 1950 to 70, that is a classical judiciary. It is which did not engage any kind of activism. 1972 to 2000, the period which judiciary or the judges established various concepts through judicial activism. Again, 2000 to till now, judicial activism which has to be flourished and touched various concepts, but it has to be intense by the judicial overreach. So these are only the what development has to be seen from 1972 till now. So let us move on to the various landmark judgment. As I already discussed regarding to the Keshwanda Bharati, that is a basic structure. And also Supreme Court revoked 122 telecom licenses, spectrum issues, allotted 8 telecom, that is company, equal to the 2G spectrum issue. And in the year of 2018, again, Supreme Court issued general ban to the firecrackers in the Delhi NCR region. And Hussain Ali Khan was accused of the money laundering. Again, the Supreme Court used terror legislation against him. So these are all an example for judicial activism. So let us move on to the what are the key mechanism and impact under judicial activism. I already mentioned that the Supreme Court has to be expanded the concept of right to life and personal liberty under Article 21, means right to life, which include right to live and human dignity, right to clean and healthy environment, right to education, right to health and medical aid, like in the case of Paramananda Katara versus Union of India, that is a bold and our doctrine has to be evolved for the upliftment of right to health and medical aid, right to livelihood, right to privacy, that is a Puttaswamy case, right to speedy trial, that is Husainara Khatun, and also free legal aid. It's a kind of the right to the every citizen who are not able to access the justice. So it is a duty of an authority under Legal Service Authorities Act of 1987. So based on that, District Legal Service Authority has to be provide free legal aid for the poor. So based, these are all the component which has to be expanded, the right to life under Article 21 of Indian Constitution. Along with that, public interest litigation has to be liberalized from the loco standi. Loco standi means right to heard in the court, but which allowed the public, that is a citizen who file a public interest litigation on behalf of marginalized and vulnerable sections of the society. So based on that, lot of public interest litigation has to be issued in the question of environmental pollution, bonded labor system, custodial violence, and also that is a which made judicial attention for overreach to the protection of the society. And basic structure doctrine I already explained, and issuing guidelines in the absence of the legislation. So this is most important element what we have to analyze in the concept of judicial activism. Even though there was a no legislation, but still the court played very important role for upliftment of that as a fundamental right. Best example, Vishaka was the state of Rajasthan. Here, the Supreme Court laid down the comprehensive guidelines for the prevention of sexual harassment at workplace. Again, until 2013, the Supreme Court guidelines treated as a law. So it's nothing but a judicial activism. Again, progressive overruling on social justice like Navajot Singh Johar versus Union of India. Again, invalidating some of an example which concerned to the invalidating the practice of triple talaq in Shabhan case, that is Shabhan versus Union of India 2017. Along with that, Menaka Gandhi versus Union of India. This is also one of the landmark case. Here, the court has to be pointed out through activism, judicial activism. That is a concept of due process, requiring the process shall be the just, fair, and the reasonable. Through that, it's a question of again the right to life and the personal liberty, along with the right to live with the human dignity. So this concept has to be introduced by the Supreme Court in the case of Menka Gandhi versus Union of India. Along with that, Husainara Khatun was a state of Bihar. Here, the Supreme Court recognized right to speedy trial as a fundamental right under Article 21 of our Indian Constitution. Again, the court intervened based on the report about under trial prisoners. In case of any under trial prisoners, even they'll convict. So they'll make an unnecessary delay in the trial. So hence the court has to be pointed out that in case of any excessive period, unnecessarily under trial prisoners has to be detained. It's nothing but a violation of the fundamental right, that is Article 21, the right to speedy trial as a fundamental right. So hence it has to be protect the under trial prisoners' rights. Again, Vishaka was the state of Rajasthan. Again, Vishaka guidelines has to be issued. Volga Tellis versus Bombay Municipal Corporation, 1985. Here, the Supreme Court expanded the interpretation of Article 21, which included right to livelihood. Again, it is a part of life, right to life. In this case, concerning about prevent the dwellers. And also MC Mehta versus Union of India in the various cases, like an environmental protection cases. Here, the Supreme Court evolved various that is doctrine, like doctrine of absolute liability, polluter pay principle. It is recognized to the right to clean environment under Article 21 of our Indian Constitution. Along with the Justice case Puttaswamy versus Union of India 2017, the Supreme Court unanimously declared right to privacy as a fundamental right. It has to be protected under Article 21 of our Indian Constitution in the digital age. Because of it, it treated as an Aadhaar case. Again, Navajot Singh Johar versus Union of India. Again, the decriminalized consensual homosexual act by the practically striking down Section 377 of IPC, that is an unnatural offenses, but it upholding the rights of LGBTs, right, and also community dignity and the privacy and the equality. So for the upliftment of right of LGBT also be, it's a kind of fundamental rights which through judicial activism, which was held by the court in the case of Navajot Singh Johar versus Union of India. Next component, the women empowerment. How the judiciary play active role for the upliftment of the women empowerment means women power. Yes, there is a lot of cases. The court have pass a judgment like an and the for example, judiciary has made significant progressive for preventing workplace exploitation of women and improving condition of data women. And then made it very clear in the case of Air India versus Nargis Mishra 1981. In this case, the Supreme Court held that in case of any air hostess to leave workforce following for first pregnancy was invalidate, and also it is an unconstitution. It's a violation of Article 14 of our Indian Constitution. Again, Ahmad Khan versus Shahbanu Begum case 1985. Again, the Supreme Court overruled the Muslim law and extended the period of vidya from 4 months to 4 months and 10 days to provide justice to the Shah Banu Begum. And I already explained Vishaka was the state of Rajasthan. So based on the judgment, that is an intervention to Article 32, along with Article 141 and 142 of that is an Indian constitution. So based on that, 2013, the Parliament enacted Sexual Harassment of Women at Workplace Prevention Prohibition Redressal Act. So again, there's a question of an adultery, that is decriminalizing adultery and striking from the Indian Penal Code one of the landmark case, Joseph Sain versus Union of India, 2018. So again, the court overruled the that is an criminal act of an adultery. Now it is a decriminalized act. Along with that, so some of the gender equality has to be propounded under Article 14 and 15. Here, the court has to be held at that an husband shall not treated as a wife like a property. So based on that, it has to be created the separate social status to the married women. So based on that, here the adultery was decriminalized. That is judges by Chandrachud. Okay. Along another important case that is based on Defense Secretary versus Bhavi Punya and others 2020, here the Supreme Court ruled that excluding the women was command position. So based on only physical characteristics and domestic duty, this classification has to be made unreasonable. Hence, it is a violation of Article 14 of our Indian Constitution. So, based on the observation made by various landmark court, again Keshavananda Bharti, again the Supreme Court, the propounded the concept of basic structure. 1918, Menka Gandhi versus Union of India. Again, the Supreme Court order in consent to the that is the due process of law and the free legal aid and also just and reasonable exercise of power. NASA Foundation versus government of that is NCT Delhi. Again, the Supreme Court decriminalized homosexuality. MC Mehta versus Union of India. Again, in the various environmental pollution and also Ganga River cleanup pollution cases and also right to education. Again, the Supreme Court order in the year of 2012, Supreme Court order the universal access to the education. So, based on the discussion, let us move on to the contemporary situation has to be faced by the judiciary. Yes, the judiciary plays continuing role in social justice. Yes, they are addressing social issue, protecting the right, but the legislature and the executive have been slow and ineffective. Again, there shall be a significant debate over judicial activism, intensive debate with the consent that it can be lead to erosion, the separation of power, or judiciary acting on superior to the legislation. So these are all the debate is going on. Again, impact of large case backlog. Despite of landmark activist ruling, there's a massive backlog over 40 million in case of case means judgment are often not enforced quickly. Again, there's a chance of diminishing their the practical impact. So these are all the impact has to be made due to the burden of court. So let us move on to the what are the issues within the judiciary. So there is lot of issue could have seen in the judiciary, even though again the question arises, judiciary is very active, but there is certain issue has to be resolved. The pendency of cases, again, the master of the roster issue, again, the population ratio, the lack of transparency, no interaction with the society. So these are all the issue has to be faced, and separating judiciary from the executive and accountability from the executive and the legislature and the executive. Even though nowadays you could have seen the corruption in the judiciary and the hardship of the under trials and infrastructure facilities. So these are all the lot of issues we can be noticed, even though that's whether judiciary is active for the upliftment of fundamental right. So based on that, I would like to make a conclusion over the judicial activism means. Yes, the scope of judicial activism is so broad, but no person definition is has to be exit. The power of judicial activism either it may review or derive from Indian Constitution, but empower them to perform an effective function than ascertaining themselves. For example, in the judiciary, protection of constitution or the rule of law, constitutionalism, yes, it which may give a strengthening to the judicial activism, but in along with the practical implication like different interest group in the society. So hence, the judiciary oversee the administration of a justice and ensure the decision are made in the public interest and the public good. Then only implementally and practically we can uplift the fundamental right, whatever the part 3 of our Indian Constitution through judicial activism. So with this, I would like to conclude my presentation by saying thanks to all for your patience listening, and I always convey thanks to the coordinator for giving me an opportunity to present my view on judicial activism for upliftment of fundamental rights. Yes, if you have any doubts, clarification, or any addition in relation to my presentation, you may feel free to ask any question. Thank you all. Thank you for your patience listening. Thank you, sir. Still, you have 10 minutes for a discussion.
Participants, anyone who is interested, who wants to put questions, can please put your questions, or they may also type in the chat box. Prajalita, are you here?
Yes, sir.
Okay, just look into the chat box if there is any questions. Okay.
Okay, sir. There is no such question till now.
Yes, participant, you may ask directly. You have any queries or doubt, clarification, or addition, you may ask directly. Directly, no issue. Hope you'll understand.
Ma'am, I think they have understood everything. It was very crystal clear.
Yes, sir.
So, Prajalita, you may kindly proceed with the formal vote of thanks. And ma'am, thank you for giving us this your dedicated time and efforts
Yes, sir.
and
Thank you
making
so
this.
much for an opportunity, sir. Thank you so much.
It's our pleasure indeed, ma'am.
Yes,
Please,
sir.
Prajalita, you can proceed.
Thank you, sir.
Okay, sir. Thank you, ma'am, for delivering such an enlightening and thought provoking lecture on the topic judicial activism for uplifting the fundamental rights in India. Your presentation beautifully uh, highlighted the role of the judiciary in protecting the constitutional fellows. We also extend our heartfelt thanks to our respected Vice Chancellor, faculty members, participants, and everyone present here for their support and active participation, which has made this lecture of Mission Nyayadrishti Samvad a remarkable one. With this, we conclude today's session. Thank you once again, ma'am, and we eagerly look forward to your continued engagement in the upcoming lectures of this series. Thank you so much.
Thank you. Thank you for an opportunity. Thank you all for your patience listening. Thank you.